Now call this 10:30 docket, which consists of case 125051. Hodes versus Nauser, MDs, PA, Gracie Lynn Nauser, MD, Appalese, versus Janet Stanek in her official capacity as Secretary of the Kansas Department of Health and Environment, Stephen M. Howe in his official capacity as District Attorney for the Johnson County, and Chris W. Kobach in his official capacity as Attorney General for the state of Kansas. Council, please come to the podium and state their appearances.
May it please the court, Anthony Powell, Solicitor General for the state of Kansas, appearing on behalf of the appellants. With me at council table is Dwight Carswell, the Deputy Solicitor General. We would like to ask 3 minutes to reserve for rebuttal, and we're here ready for argument.
May it please the court, Caroline Sacerdoti with the Center for Reproductive Rights on behalf of plaintiffs Appalese, Dr. Tracy Nauser and her practice, and with me at council table is Teresa Woody.
May it please the court. In 2011, the Kansas legislature passed Senate Bill 36, codified at 65-4A01 through 12, and were scheduled to go into effect on July 1st, 2011. Portions were later amended in 2015. The act provides for the licensure and regulation of facilities that provide abortions in Kansas. Significantly, the act allows KDHE to grant exemptions to the act and accompanying regulations when it determines that the welfare of the community require the services of the clinic and that the exceptions will have no significant impact on the health, safety, or welfare of its patients. The act authorizes KDHE to issue regulations for abortion clinics covering all such operations, including sanitation, operating procedures, recovery times, follow-ups, staffing, record keeping, and reporting. Significantly, KDHE looked to the ambulatory surgical care center regs as guidance. In addition to Planned Parenthood's facility in Overland Park was licensed as a ambulatory surgical care center. KDHE consulted with abortion providers and the public and received public comment and issued regulations in response to those comments. However, before the regulations took effect, the plaintiff sued to enjoin both the act and the regulations, claiming that they violated the Kansas Bill of Rights and the right to abortion. The district court temporarily enjoined enforcement. During the litigation in 2015, the legislature amended KSA 65-4A10, which required that abortion drugs be administered by the physician or in the physician's physical presence, as well as added some exceptions. The plaintiffs amended their complaint to include this amended version of the statute. Following discovery, the parties cross-moved for summary judgment, and the district court granted the plaintiff's motion and permanently enjoined both the act and the regs. The district court held that the act and the regs infringed on a woman's right to an abortion, while the district court acknowledged the state's compelling interest in regulating the medical profession and maternal health. It found both the act and the regs do not further this interest. It's the state's view that at the initial analysis in this type of litigation, that it's the plaintiffs that had the burden to show that somehow the act or the regulations would infringe on the right to an abortion. And once that is shown, then the burden falls to the state to show that there's a compelling governmental interest and that the regulations are narrowly tailored to establish that governmental interest. The court in Hodes recognized that not every law which makes a right more difficult to exercise is ipso facto an infringement of that right. If the action only appears to contravene a right without creating any actual impairment, then there's no constitutional violation. It's the state's view that the plaintiffs have not met their burden. The United States Supreme Court, since Casey, has recognized that abortion doctors do not get to set their own rules. They're not permitted to self-regulate. What's, I think, most concerning for the state is that the plaintiffs oppose all the regulations that were propounded, even some what I would at least judge as some of the least innocuous among them. It's the state's position that neither the act nor the regs impose any requirements on a woman who is seeking an abortion for her to satisfy before getting such an abortion. The act and regs create minimum standards for health and safety, and the plaintiffs haven't shown that they will infringe on a constitutional right to abortion.
You know, there are several tests, I guess, that you could use for, or that one could use for infringement, like you're talking about, whether it contravenes a protected right versus actual impairment. Which test would the state propose this court use?
It has to actually impair a right. It has to contravene the ability of a woman to obtain an abortion. That has to have a meaningful blockage or impediment to that is our view. And our view here is that the regulations don't in fact do that. We acknowledge that, and I made this point in the other case, that with any fundamental right, you have time, place, and manner restrictions. In our view, these regulations, while perhaps imposing some inconvenience, ultimately do not impair a woman's ability to obtain an abortion.
So under Casey, an incidental effect is not enough. There has to be direct causation.
Yes.
Okay.
Uh,
And so in Hodes 1, we said the fundamental right infringement, regardless of degree, if it infringes on a fundamental right, it triggers strict scrutiny. But you would not go with that. You would go with the direct causation.
Correct. It's our view that, of course, as we've already had a lengthy discussion, we obviously think that Hodes was wrongly decided, but trying to at least keep generally within the framework is the argument that we're trying to make today, that we still think that these regulations don't meaningfully impair a woman's right to obtain an abortion and do promote maternal health and safety, and are therefore worthy to be supported.
What's the standard by which we could decide meaningfully impair?
It's a material difference. It obviously sort of hinges on the facts, I think, to a certain extent, but yes, in my way of thinking, it something that's going to negatively impact their health, something that.
But what if every abortion provider just said, I'm not doing it, I'd rather retire? Would that be a meaningful impairment?
It would depend on how many abortion doctors
All
are
of
in the
them.
community, but I think
All of them.
I don't think it does, no, because I don't think you can make an abortion doctor perform abortions. So there's no right to perform abortions. There's
So then
a
how-
right to obtain an abortion.
Are we supposed to, as a court, then make some kind of judgment about the reasonability of the regulation to decide whether or not it meaningfully impairs
I
the
think
right?
I think reasonability does factor into it because
I mean, just to make an absurd example, if the state said every provider of this service has to post a $1 trillion bond before they can do it, we could probably say that might be a meaningful impairment, because who could do that? Would you agree with that?
I agree.
So at some level, we have to look, I mean, it sounds like what you're saying is we have to look at the reasonability of the regulation itself.
Correct.
What, can you identify for me, what are the interests that the state is identified as compelling?
I think there are two interests here. Obviously, maternal health
Okay.
is probably the most significant one, but the state also has the interest in the integrity and proficiency of the medical profession. That's why the medical profession is heavily regulated. So that's the other interest. We want to ensure that physicians that perform procedures are doing them properly and with the utmost safety in mind. So those would be the two compelling interests. that the
Why is
state
the
looking at.
latter, regulate, you mentioned it, that physicians are highly regulated. Why isn't that? Why does the statute get to substitute its regulations for already in place or professional regulations that doctors and physicians have to abide by? I don't understand why that rises to make it compelling when there's already a governmental mechanism in place that ensures the public's safety.
Well, let me make 2 points about that. One is, just as a general proposition, as you've indicated, the state has a compelling interest in ensuring the public safety and health through regulating the medical profession.
No,
So we have
I'm
that
saying,
right.
why is that a compelling interest when there already is a mechanism? It might be, and again, this is hard because you talk about legitimate, compelling. It might rise to a legitimate, but the what makes it compelling is something that is rare. How we described it in Hodes, and I don't understand why the medical profession interest here is compelling.
Well, the district court sort of saw it your way. They had some, well, in the other case, but our position is that abortion is different. And that's what separates these particular regulations and why these particular regulations focused on the practice of abortion are different, because the state's interest in ensuring, since the act of abortion and the procedure takes a human life, that justifies the additional regulation over and atop what general regulations may exist governing the medical profession.
So are you saying that the interest is not maternal health, and in your briefing, it's really tied to Kansans health, and then a little more specifically maternal health? But are you amending that even today to talk about maternal health in abortion is the compelling state interest?
Our view is it's general. We have an interest in the health of Kansans, and we in particular have an interest in the health of maternal health for women. So those are all compelling governmental interests that we're just trying to further with these regulations. But the additional issue with regard to abortion, as I've indicated, is because abortion is a procedure that takes a life, that enhances the interests of the state, because there are, risks
So that's
with
part
abortion.
of your compelling interest? I'm just trying to.
Yes.
Okay.
So
How do these regulations further that interest, though?
Well, it's the state's position, and we had testimony from our expert that said that the regulations were reasonable, that the regulations enacted by KDHE were regulations that could be easily met by providers, that good providers would already be meeting those expectations. And
But that
so,
doesn't go to whether or not it furthers the maternal health in abortion. The reasonable, whether they're reasonable
Sure,
or
I
whether
think
they're
it
easily
does.
met.
I think it does, Justice, actually, because
Well, what you said in your briefs is the challenge laws attempt to ensure women deciding whether to continue pregnancy have access to a safe environment to exercise that right.
yes,
And to,
I think that's what I'm saying. Maybe I'm not saying it articulating as well as I could be, but I think that's what I'm saying.
So
I'm
Go ahead.
done.
I want to kind of scale back and ask some big picture questions. Whatever the rule that comes out of this case is, it will apply to all medical procedures that touch on bodily autonomy, I presume. Is that correct?
Yes, potentially.
And so it would apply equally to an appendectomy, as to an abortion, as to open heart surgery, as to setting a broken arm or what have you.
Right.
That being the case, what does the state really have a compelling interest in regulating the medical profession in toto?
Yes, I mean, I think we have a duty, because the public can't know who a good doctor is from a bad doctor.
Well, why not? Why doesn't the market effectively regulate? I mean, this is compelling interests are the highest form of state interests that exist. You know, all the states went a long time without regulating medical industry at all. If we're really talking about a compelling interest, I mean, if we're really talking about applying strict scrutiny to every regulation of the medical profession that's on the books, is that what we're doing? Is that the rule that comes out of this case?
That shouldn't be the rule.
No, but is it the rule that comes out of this case?
Well, my concern is that might be the rule.
But you've conceded it already. I mean, I'm puzzled a little bit, I guess, by the state's
I guess I
position.
didn't think that's what I was saying, Justice. Obviously, our primary interest in this case is protecting the health of women.
But
And that's what we're trying
But
to
you're
further with
arguing
it.
the state has a compelling interest to regulate the medical profession. And I get that from your perspective, you're quote unquote stuck with that. Am I articulating your view correctly?
Oh, I think
Okay.
you're articulating the state's view. See, my time has expired. Any other questions from the court?
The district court's factual findings were that the state did not identify any safety concerns particular to abortion for the purposes of being singled out for this special treatment. That's supported by substantial competent evidence.
Well, the record is, Justice Biles, as the record is, I think our view is that that isn't critical to whether you can uphold these regulations or not. If they enhance the safety for women, that's enough. It does, even if the existing general regs provide safety, the fact that we want to increase that level of safety, we think is appropriate.
Right, but I mean, in the grand scheme of administrative regulations or even laws about this is this case is framed and I think needs to be analyzed as an overregulation case. Killing an ant with an atom bomb, in effect. You're overregulating and thereby not gaining anything other than restricting access to abortion. Isn't that right? I mean, that's the way the district court at least framed it.
One of the regulations in here, and I think it's interesting, I don't recall the district court actually squarely addressing it, but it has a provision in there that requires follow-up with patients to make sure to see how they're doing, assuming that they consent to that. That strikes me as something that enhances the health of women and patients.
Then why shouldn't we require that of the entire medical profession? The issue is you've singled out one procedure and it looks like government animus, Kansas legislature being so friendly toward regulation of business. And so, I mean, that's what I get out of the district court's findings is that we're doing all of this. There's no real purpose for doing it other than maybe making it a little tinier, safer. But the negative effects are, what was found by the district court, which are substantial. Anyway, so again, it gets back to over-regulating the problem.
Again, our answer is abortion is different. That's the state's answer is because abortion involves the taking of a human life. It justifies additional, as you characterize it, over-regulation to protect patients. That's our position, Justice.
I have one other question that kind of goes to something you said at the beginning, which is that the plaintiffs in this case object to every single regulation. Which party has the burden to prove the severability issue?
I suppose, well, it depends on what the court's ruling is in terms of severability.
Well, the district court ruled that it couldn't be severed without, you pull out, 3/4 of the cards and the whole deck falls.
Right.
So who bears that burden?
Well, I suppose since it's our regulations that we're defending, we do. But our view is that with the severability clause, some of these regulations could have been saved. I think the one I just talked about, the patient follow-up, it's post-abortion. That process happens after the abortion's already happened. So I'm having a difficult time seeing how that would impair the right to obtain an abortion. That seems more going to the bigger question of, well, you saddled abortion clinics with these regulations. Are you gonna, drive up costs or drive people out of business? But the interesting thing about the record in this case is that there is no specifics about, well, these regulations are going to cost this much. It's going to have this amount of impact in terms of the number of patients we can see. It's going to drive so many providers out of business. We didn't get any of those. Kind of like in the other case, what we were treated with was mostly conclusory statements about, oh, this may impact patients in some sort of undefined matter. That's the concern I had when I was reading the record here, just having been a district judge. I'm thinking these are, once again, I'm seeing conclusory statements, and
Well,
it's
they were an
hard-
of an affidavit again, which was
right.
submitted
But
as evidence.
affidavits are drafted by lawyers, and I'm just, part of the problem that I had
Do
here.
you have any evidence that the affidavits in this case were drafted by attorneys?
I don't, but I just kind of know how the process works, and that's typically lawyers
Also, I noticed
help
in
their
that-
clients,
I-
prepare their affidavits.
I noticed in the briefing that you criticized the district court for not conducting a regulation by regulation severability analysis. But you never did that before the district court, and you didn't do it to us either. Is that correct?
That's correct. Yes, our view is that if you're going, when you have a severability clause and you've made broad sweeping conclusions about all these regulations without making findings as to particular regulations that are being upheld or thrown out, that's troubling to me, because I think that some of these regulations wouldn't have an impact at all.
Well, what's the-
And
what
the one
is-
I'm citing was
But
the
didn't you just
24-hour
concede that
wait.
the state bears the burden on the issue of severability?
What is the legal test for determining severability when there is a severability clause?
It's whether the act would work together even without the challenge parts, is my understanding of what that test is.
And is there a part of that that asks whether or not it would have passed the legislature without the severance
Yes.
parts?
Yes,
And is there a presumption that attaches when there is a severability clause?
yes,
Presumption is in favor of severability, correct?
yes.
I'd just like to push a point to clarify something that might be very dangerous if misinterpreted. You mentioned that about the affidavits. The affidavits were evidence, correct?
Yes.
And you're not suggesting the affidavits were not the sworn testimony
No,
of the
I'm not,
physician?
I'm not suggesting that there's anything improper. I'm just saying, in the normal course of lawyers advising their clients, they always, of course, help their clients prepare their affidavits. So I'm not suggesting they put words in their mouth or anything like that.
Well, I wanted to ask you about footnote 28 on page 47 of the district court's findings that reference the defense expert, Dr. Haig, and her comments that several of these regulations, and they're enumerated in the footnote, are unnecessary. So why should they be in place?
Well, the record is, Justice Biles says the record, our witness wasn't as helpful perhaps as we would have liked, but that's the evidence. I guess, again, our view is that whether they were necessary in the opinion of a particular doctor or not, the fact is that the state, given the interests at stake here, are justified in having additional regulation to try to promote and enhance the safety of patients. And that's our position.
Can't connect the dots on that. On what you just gave me is a conclusion, and you can't connect the dots from any sort of evidentiary basis as to why that conclusion. Which I mean, I think our court is in the same place maybe you are, as being constrained by the case as it comes. The district court looked at the facts, made findings, And now here we are. And there's really no challenge to the findings of fact that have been made here. And sort of compels the conclusion, doesn't it?
Well, Justice, again, the record is as it stands, and I've given you our position, but let me point out a couple of things that the district court threw out, but the regs appear to be, entirely reasonable and promote safety. For example, the regulation that requires another person to be present when the doctor is performing either abortion or a pelvic exam. The plaintiffs objected to that, even though they conceded that it was part of the standard of care for if there's a male doctor to be working with a female patient, obviously, that there should be another person present, and that obviously enhances patient safety. So we've got a reg that's
But it
very,
doesn't.
that's
I mean,
very
your own
close.
expert says it doesn't. So again, the statements of counsel aren't evidence. And the evidence is all of the doctors at least agree as to footnote 28 that those regulations aren't necessary and don't do anything for patient health or safety.
The other thing
Conclusion.
The other thing I would say, Justice, is, for example, the plaintiffs objected to the reporting of waste disposal methods. And they, I think, speculated that it would cause, some of their, the companies that they ship their medical waste to go out of business. Well, we didn't hear, though, from the medical waste collectors themselves, and it ignores the important state interest. There's actually a statute that forbids the sale of fetal tissue. And so I can see where a reporting statute like that would aid in the enforcement of that particular statute.
How does that further maternal health?
Well, that particular statute doesn't further maternal health. That's a different interest. I grant you that. But to me, that strikes me as an important reason to have that particular, in addition to, wanting to promote maternal health. But I can see the argument that maybe that particular provision may not directly impact maternal health, but
And yet
it does further some other important state interests.
Yet it is one that the record in the case identifies as maybe the most likely to cause this clinic to close because of its inability prep for disposal.
I appreciate that that's what the doctor said, but and
That's the record we have.
any other questions for the court? I see my time has expired. All right, thank you.
Pastor Doty?
Madam Chief Justice, and may it please the court. The undisputed facts make clear that the state has not even come close to meeting its extraordinary burden under strict scrutiny to show that the laws challenged here actually further a compelling interest and are narrowly tailored to do so. The court should affirm the district court for two reasons. First, by targeting the fundamental right to abortion with an entire unique regulatory scheme, the laws infringe on that right. They create an additional scheme just for abortion care that applies on top of Kansas's multiple generally applicable schemes governing healthcare to which plaintiffs are already subject. The laws do not apply to comparable care or care that the experts in this case agree is identical to abortion care.
Speaking of comparability across the spectrum of medical care, do you agree with the state that whatever the rule is that comes out of this case has to apply to all state regulations of the medical profession?
I do not agree that all regulations governing healthcare would be subject to strict scrutiny.
Why not?
Because as this court found, any infringement, regardless of degree, warrants a closer look. Now, as the court recognized in its 2019 decision, sometimes that's obvious. And I think that is the case where you have laws that target a fundamental right for unique regulation. But where you have generally applicable laws, those do not target the right for unique regulation.
What is the right at issue?
The right at issue here is the right to access abortion care
I
as
thought it was bodily autonomy.
the right to access abortion care is a necessary
Subset,
part.
right?
I would say it is an absolutely crucial part of our ability to control our own bodies.
For purposes of these questions, I will completely grant you that it is clearly a entirely subsumed subset of the broader category of bodily autonomy. But would you concede that the category of right pronounced by the court in the 2019 decision was a right of bodily autonomy?
I would agree that that is part of the right to personal autonomy as recognized by the court.
And doesn't, maybe not all, but don't a great many aspects of medical care not infringe, that's the wrong word, but touch upon bodily autonomy?
That may be the case, and it's sort of difficult to speculate as to how far that right
Well, let's
would
just take
reach.
another surgical procedure. Doesn't a surgical procedure implicate the right to bodily autonomy?
Yes, I think
So
that's
in other
right.
words, the government has to satisfy strict scrutiny before it can regulate a surgical procedure. Correct? Under our decision in Hodes. That's what it says.
I am not sure that that's necessarily the case. Perhaps it is. It is difficult to speculate in the abstract. But what I do know is that in the 2019 decision, this court recognized that abortion is part of that right.
Correct. But I think it's important to understand the scope of the rule that you're asking us to pronounce. It strikes me as I was questioning the Solicitor General that whatever the rule is, if we're going to demand that the state satisfy a articulation of a compelling interest to regulate a surgical procedure, the state may not be able to satisfy that for any surgical procedure.
I don't necessarily agree with that. I would say that
Why not?
strict scrutiny is only, the first part. Well, the first part of the inquiry is infringement, and then you get to strict scrutiny, and then you have to actually apply that. And so,
Well, let me just ask, do you think the state has a compelling interest in regulating a surgical procedure?
I think the state has a compelling interest in regulating or in furthering the health and safety of Kansans. I do not necessarily agree that it has a specific interest in regulating the health of pregnant Kansans seeking abortion. That is distinct from that interest. And I would say that as to regulating the medical profession, as the state articulated below, the point of regulating the medical profession is to further the health and safety of Kansans. The two are tied.
Sure. Do you think that if an ambulatory surgical center objected to some of the regulations and they challenged them as being unconstitutional as a violation of the right to bodily autonomy in Section 1, do you think that a court would be required to apply strict scrutiny to that challenge?
No, not necessarily.
Why not?
Because this court has recognized that abortion is a fundamental right, and it has not recognized that all of the various procedures which are typically provided at an ASC such as plastic surgery is necessarily.
Can you distinguish abortion care from plastic surgery in a legal sense with respect to Section 1?
I would say that this court recognized that abortion bears on our abilities to, control our own health. And it also bears on our abilities to make decisions about our bodies.
So
Yes,
abortion is
but
special is what you're saying when it comes to healthcare.
I am
It's
saying-
different from other forms of healthcare.
I am saying that the court has recognized that abortion does bear on our abilities to control our own bodies and to create families, which are crucial to our dignity.
Doesn't
interests.
plastic surgery do the same thing?
I can't speculate as to that. I can say that the court has not recognized that plastic surgery is a fundamental right. So I'll turn again to the record. So I would say that the district court's decision was based on 3 undisputed key facts. First, as I said, the laws create an additional regulatory scheme that applies on top of Kansas's generally applicable schemes governing healthcare, to which plaintiffs are already subject. This scheme imposes a comprehensive set of regulations spanning a dozen categories, and it does not apply to identical care such as miscarriage care. I would say, second, there is no dispute that abortion care is identical or similar to other care, and that the laws do not apply to that. And third, there is no health and safety reason to regulate abortion differently than that identical care. And
Those all go to the narrowly tailored, or, I mean, have we skipped over the compelling interest and moved on to strict scrutiny for narrowly tailored?
I wouldn't say that they all go to narrow tailoring. I would say we don't contest here that Kansas has a compelling interest in health and safety. So these facts bear on whether the laws further that compelling interest and are narrowly tailored. And the state has made no showing that the laws do actually further its asserted interests or are narrowly tailored.
So the health and safety of, I guess this goes to Justice Stiegel's question. If you can have this very broad, and as Justice Ball says, even overbroad stated interest of the health and safety of all Kansans, and that can be a compelling interest, then doesn't that necessarily, well, I guess first you have to find that there's an infringement of a fundamental right.
Right. So I think that is key. Where there is infringement of a fundamental right, so where we have laws that target that fundamental right for unique regulation, that warrants.
Okay, but if I have a fundamental right, I want to have open heart surgery because I need a quintuple bypass because I am 99% blocked in all 5 arteries. And do I have a fundamental right to have that surgery? Not die?
I would
Under
say,
my personal autonomy under Section 1? I think this is what Justice Stiegel's going to.
right. I would say that the court has not recognized that, but I can see how other forms of healthcare, yes, could also be under the umbrella of personal autonomy and subject to the protections that are accorded with that.
Okay, and then the question is, when you have this really broad stated interest, instead, then it kind of goes to whether it's narrowly tailored to when you have a really broad stated interest, then it's hard to narrowly tailor something to a really broad interest, like health and safety. Because then wouldn't you need to make sure that all pregnant moms are fed, and get prenatal care and, right?
Yes. So I would say there must be, under narrow tailoring, there must be precision of fit between the means and the compelling interest. And here, there's no indication in the record that creating an entire regulatory scheme to target abortion has any health or safety interest. And so the laws are not narrowly tailored. They are also both under and over inclusive. They're over inclusive in that once they are triggered, they apply to all of the healthcare provided at a medical facility, not just abortion care. So, for example, one of the requirements is that that medical assistants cannot administer medications to patients, which the experts agree, is appropriate and well within the capabilities of medical experts, what they routinely do. Once these laws are triggered, they would not only prevent plaintiffs from using medical assistance to administer medications related to abortion, but also medications related to the broad range of obstetrical and gynecological procedures that are provided at plaintiff's practice. The laws are also under-inclusive in that they do not apply to miscarriage care or other forms of comparable care. And so that in and of itself is sufficient to show that these laws are unconstitutional.
Wondering if some of this dialogue isn't a product of appellate judges, as I am worried about unintended consequences, by the way. So I recognize the question I'm going to ask you is not, well, no, I guess it is here in this case. We looked at Roe, where the court said there was no compelling state interest in abortion care in the first trimester. It seems to me that's one thing, but there's still going to be a state interest in how doctors do what doctors do, right? Seems like that's got to touch upon a compelling interest of the state to be able to regulate a profession like the medical profession. May not justify targeting or, without evidentiary justification. That's, you can target anything you want if you've got the facts, but you don't just assume something. My question has to do with whether we're constrained by the Roe analysis about abortion care in the first trimester, because this would apply to the first trimester. See what I'm getting at here?
Yes, Your Honor. So in response to that, I would say we haven't contested the state's interest in health and safety, including in the first trimester.
Say that
One of the
again.
ways,
So say that you haven't contested.
We haven't contested that the state has a compelling interest in regulating the health and safety of Kansans, including in the first trimester. Our issue with these laws is that they target the fundamental right for unique regulation, and there is absolutely no showing that that infringement on the right is warranted. The state has not met its burden here.
one of the ways we avoid those unintended consequences that Justice Files talked about is to write a very narrow decision if we can. And it strikes me that one possibility here, based on if we were to accept your argument, would be to simply say that we have uncontested record before us that at least several of these regulations do not further health and safety. And can we just end then? Is that all we need to say? Assuming that we also would decide that that you can't pull those out and have a few hit things here and there still applying, but rather that we would say the entire statute or the scheme is unconstitutional.
Yeah, so what the laws themselves coupled with Kansas's existing generally applicable laws show is that the laws work as a scheme as a whole. And so in that way, they infringe on the right. And I would add that this is also buttressed by the record of evidence showing that the laws in practice would, as written, preclude plaintiffs from continuing to provide. They are actually impossible to comply with. And they, even if plaintiffs could comply, they, impose a heap of onerous restrictions. But so my point is that we have shown infringement sort of in two ways. Then turning to the application of strict scrutiny, the state has made no showing on the record that any of the laws or any of the requirements that we have challenged further an interest. And so they have not met their burden as to any of those restrictions.
Stop there.
Yes. I would also add that the district court granted summary judgment for plaintiffs also on our equal protection claims on behalf of patients. And so that would provide another basis for this court to make a decision in this case. And if I may, I see that I'm out of time. I would like to address the severability piece. I would note that the presence of a severability clause is not dispositive. The test is whether the laws would have been passed without the objectionable portion, and also whether the statute would operate effectively to carry out the legislature's intent with that portion stricken. Regardless of who carries the burden, we have shown that severability is not appropriate here because the laws are a scheme. They're interdependent with multiple cross-references within the statute and within the final regulations. There's no indication which parts would survive without the others. And trying to pick apart the scheme would ultimately contravene the legislature's intent. And trying to figure that out would also put the court in the seat of a legislature. And so for those reasons, severability is not appropriate here.
So to go to Justice Stiegel's point, in Gannon, we held that the severability clause creates a presumption of severability. So you're saying that the test, then you do the test if the legislator to overcome that presumption. If the legislator would have passed the act without the objectionable portion, and if the statute can still operate effectively, that overcomes the presumption.
Yes, that's correct. The severability provision is not determinative. If the court has no further questions, I would ask for just a minute to close up, but I recognize I'm out of time.
Questions, and yes, you may. To wrap up.
So I'll just emphasize again, the purpose of recognizing that a right is fundamental is to ensure that where it is targeted for unique regulation, courts take a closer look. And so because of that, the state has made the burden here, and it hasn't shown that the laws further an interest, not merely in theory, also in fact. Its sole expert agreed that abortion is medically comparable to other care provided in medical offices and should be regulated as such. And I would add that the state has not submitted a declaration or affidavit on behalf of their expert. The expert, the document that the state cites to quoting their expert is actually an amended expert witness disclosure, not a declaration or affidavit. Finally, during the more than a decade since the laws were enacted, and since the state has agreed not to enforce these laws, the state has pointed to no health or safety issue regarding abortion care at a facility in the state, much less any issue that these laws would address. For these reasons, we ask the court to affirm the district court's decision declaring the laws unconstitutional and permanently enjoining them. Thank you.
Now you reserve 3 minutes.
Thank you very much. I'm just going to make one point. Dr. Krishna Rajana had his medical license revoked when an inspector, and he's an abortion doctor, had an inspector found a dead rodent in the clinic hallway. And so there have been some problems in the past. Dr. Kermit Gosnell is probably the most notorious one, but that's not here in Kansas. But so there have been issues of safety. That's the point of these regulations. And we'll just stand on our brief with the remaining arguments that I have. And if you have any questions, I'd be happy to try to answer those.
Was the incident that you just told us about something that came up in the normal regulatory process?
So,
But didn't need these extra things to deal with it?
well, it's hard to say for sure, but
Well, it happened.
I mean, that's
So
that's what motivated a lot of these regulations was the stories of some of the horror stories. And that's what, generated the interest in trying to create additional regulations. There's some concern that maybe some doctors weren't doing everything they needed to do.
but without a factual connection to the state of Kansas in terms of what the regulatory, I mean, I know there's that Pennsylvania or whatever it is out there. Example that gets talked about, but that was a long time ago, but there's nothing in the record that shows that the regulatory scheme that that doctor was in was comparable to the Kansas scheme.
True. Thank you very much.
With that, the court will take this appeal under advisement.